And this is a terrible thing to say, but it's truth. In these anti-gun jurisdictions, they really do prioritize the rights of criminals, violent thugs, over the rights of ordinary Americans.
I mean, how is that possible?
If they take the case, we have a virtually 100% chance of winning.
Yesterday afternoon, Abigail Spanberger signed HB 40 into law. This is one of the most draconian pieces of gun legislation anywhere in the country. HB 40 takes normal, law-abiding gun owners, and depending on what you have, it can turn you into a felon overnight. Now, in just a minute, I'm going to talk to Professor Mark W. Smith. You probably already know who he is. If you know anything about the Second Amendment, he's a constitutional attorney, member of the United States Supreme Court Bar, and the top voice of the Second Amendment 2 years running, right? He's the real deal. But before I do that, here's some context on what HB 40 actually does. Possessing an unserialized firearm or unfinished frame leads to 12 months in jail. Possessing an unserialized firearm or unfinished frame for the second offense is a 2 to 10-year prison sentence. Again, not for being violent, not for doing anything wrong other than possessing a gun that you bought legally, right? And possessing or manufacturing a non-detectable firearm, again, possession only, 1 to 10 years in prison. You will never own guns again for the rest of your life. The craziest part about this is that there is no grandfather clause. If you've already purchased one of these guns, when this ban comes into play, July 1st, 2027, you're just screwed. And that's just the unfortunate reality. This is, no joke, one of the worst laws I've ever seen in the United States, and that's why we're bringing on Professor Smith to talk about it. Before I do that, though, if you are new here, please do consider subscribing. It makes such a difference to the success of this channel, and I really appreciate all the support so far. It makes more of a difference than you realize. Also, if you're not already subscribed to the Four Boxes Diner YouTube channel down below, make sure to do that. It is the best Second Amendment channel on the internet. Mine doesn't even come close. All right, let's get into it. Mark, I really appreciate you coming on the channel and making everyone the smartest guy in the room. That's what you do on your Four Boxes Diner channel, and it really means a lot to the whole movement. Now, from a constitutional perspective, how is a ban like this possibly constitutional?
Well, really, HB 40 is not constitutional because if you just look at the plain text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. So take a look at the words to keep and the words to bear. What does that mean? Well, the Supreme Court's already told us what this language means. The words to keep means to possess. The words to bear means to carry. Well, obviously, if you want to possess an object, if you want to carry an object, whatever that object is, guess what you got to do first? You got to acquire it. Well, guess what? In America, the way you acquire any object is you either buy it or you make it or you inherit it, right? You acquire it in some way. So as the Supreme Court has repeatedly said in many different cases, there are concomitant or ancillary rights kind of implied within the text of the various aspects of the Bill of Rights. So one such thing when it comes to the right to keep and bear arms is there's sort of an implicit right to acquire them because, again, you can't keep and bear something that you can't first acquire. The reason why that's significant is this law, HB 40, just signed into law by Governor Spanberger there in Virginia, is essentially a regulation, a government restriction, a government hindrance on the ability to possess, to acquire an arm. Because they're basically saying, if you want to make your own firearm, then there's certain things you now have to do as required by the government. Specifically, not only do you have to etch some serial number on it, but more importantly, you have to bring it to a federal firearms licensee, an FFL, and have that serial number recorded so that now your privately made firearm that you made in your garage is now part of the FFL database world that members of the government can go look at it. So again, it's clear that as a matter of plain text, this is a government regulation on the activity of acquiring an arm, i.e. you make your own arm, and as a consequence, it essentially interferes with or touches fingers with the right to keep and bear arms. And once that occurs, as you know, the burden shifts to the government to justify the modern-day gun control law through history. And when you look at the history of gun making in the United States, there's basically no restrictions whatsoever outside of the context is if you go into business. Now, again, if you're in the business of making and selling firearms, that's a commercial activity. There are regulations that can attach to it. But if you're just making something for yourself in your garage, that is an entirely different set of historical traditions and facts.
Yeah, and we've seen them also, of course, go after gun manufacturers with all the PLACA workarounds. And so,
yes, that's a whole separate thing. But yes, of course.
That's crazy.
Look, the reality is that people like Governor Spanberger and people that hate guns in the United States, they don't hate guns. And this is the great misunderstanding, that the anti-gun movement in America doesn't hate guns at all. They like guns. They just want to be in charge of the guns and have we, the people, disarmed because they have big things planned for us. Why else would you not trust the American citizens that have the right to vote for democracy, have the right to vote for president, their elected officials, have the right to make decisions about their property, their homes, their children, all this kind of stuff? Why don't you trust those same people to make decisions about how they protect themselves with firearms? And the answer is they must have big plans for us, and having an armed citizenry is getting in their vision of the future, which is exactly what the founding fathers had in mind. For anyone that had tyranny on their mind, they wanted to make sure armed citizens were there as one of the checks on an overreaching federal government, among other things.
And it seems like the Supreme Court does understand this, and they've shown, an ability to do stuff about it. And we've seen Harmeet Dillon just in the last couple of days post, multiple times on Twitter that she has her eyes on Virginia. But what everyone's kind of focusing on here, and I've made a point of this on the channel, is everyone focuses on the assault weapons ban, right? Which bans pistols and shotguns, and it's terrible. But you haven't seen the same media attention on HB 40. So just from your point of view, where do you see this going? Where do you see the timeline going? And when do you think our friends in Virginia will get some relief?
Well, on the good news front, when it comes to HB 40, I don't believe that law dealing with privately made firearms goes into effect until January 2027. At least that was the last version of the bill I saw. So there's a little bit of time to engage in litigation and try to resolve it. So the question is going to be is what will the United States Department of Justice under Harmeet Dillon, will she immediately start suing over these specific laws? Will she wait until additional gun control laws are signed into effect by Governor Spanberger? That's going to be a strategic decision by the Department of Justice. Remember that one of the issues that the Department of Justice is going to face here is that Virginia falls, unfortunately, in the jurisdiction of the United States Court of Appeals for the Fourth Circuit out of Richmond, which is one of the worst courts in America when it comes to protecting our Second Amendment rights. So the odds of getting any kind of real relief in the Fourth Circuit may be a little difficult. It may ultimately require the U.S. Supreme Court to intervene. The good news is that the one thing that we all agree upon, and this is just basically understood at the Supreme Court bar, there's no dispute about this, that if the United States government, through the Solicitor General's office, which would be John Sauer working with Harmeet Dillon, if they request the United States Supreme Court to get involved in an issue, the Supreme Court almost always gets involved. So if the Solicitor General's office with Harmeet Dillon is willing to work together to push this to the U.S. Supreme Court, there's a good chance the Supreme Court will take this case because, again, they look very carefully at what the federal government wants them to do, and that gets considered seriously. And, again, it's rare for the Solicitor General to want a case to be heard and the Supreme Court to say, no, we won't do that.
Good. And bridging on from that, one of the big questions I've seen all over the channel in the comments is people kind of wonder, if I keep one of these things and then later down the road, 2 years down the road, we do win and we get this, struck out as being unconstitutional. And let's say you catch a conviction or some other charge for that crime in the middle. Would those be retroactively removed, or how does that process work typically?
Well, generally speaking, and Justice Scalia was quite good on this issue. However, the Constitution should be interpreted correctly today is how it should have always been interpreted. So from a retroactive point of view, yeah, generally speaking, if there's a decision made that something was wrong in the past, it often is retroactive. Now, of course, that varies from case to case and situation to situation. But what you really want to do in a perfect world is you get a relief ahead of time from the court. You get an injunctive relief because, again, if you get the injunctive relief and the court says, look, state of Virginia, you're not allowed to enforce this law, we're going to enjoin it, that is really what you want. For example, in the famous Duncan versus Bonta case out there in California, where you had the California statewide ban on magazines that held more than 10 rounds or whatever it was, Judge Roger Benitez in the Southern District of California entered an injunction that said, look, this law is unconstitutional. And there was a period of time of a week or 10 days or so where that California ban on magazines was enjoined. It could not be enforced. And it was during that time, apparently hundreds of thousands, if not millions of magazines that had more than 10 round capacity flooded, if you will, in the state of California. And those individuals can still possess those magazines today. Now, if that injunction ever goes away, because, the Supreme Court doesn't hear cert in the case and the Ninth Circuit decision against the Second Amendment, was upheld, well, yeah, there's a real risk they'd have to give those magazines back or give them up or move them out of the state. So, yeah, it's a little tricky here. The right answer, of course, is to try to get a relief ahead of time. Yeah. But obviously, anyone who's listening to this channel needs to understand, they have to comply with the law. They should comply with the law, even if we disagree with the law, because we don't want to see anyone in the Second Amendment community, especially in these terrible jurisdictions like Virginia has become, we don't want to see any of them going to jail, because the reality on the ground is, and this is a terrible thing to say, but it's truth, in these anti-gun jurisdictions, they really do prioritize the rights of criminals, violent thugs, over the rights of ordinary Americans. So they're much more willing to punish a ordinary American for a malum prohibitum crime, which is a nonviolent regulatory crime. They're much more willing to put those people in prison and do terrible things to them than, for example, they would to an actual thug that engages violent crime. We saw this with the Daniel Penny case in New York City, the Marine veteran, right, who was basically almost put in jail for many, many years for allegedly murdering a homeless person who was threatening a subway car. So what does New York City do? What does the district attorney do? They go after the guy that's the hero that saves the subway car and tries to put him in prison. So that is the danger of these places like New York, New Jersey, California, and Virginia, that even if you do everything according to Hoyle, they're looking to get you. They're hunting you is the reality on the ground. And I mean hunting in the sense of legal. They want to put you in prison and not the thugs that they view, in my opinion, as the constituency of the modern Democratic Party.
It's crazy that we're at a state now where we can say Virginia is one of the states you got to stay away from. It was always New York, California, all the regulars, but now Virginia as part of that is it shows you how much things can change in one election cycle. It's really insane.
But remember, Virginia today has over 1.2 million foreign-born people.
Right.
Foreign-born people. And the 37-year-old born in Bangladesh, state senator led the charge for a lot of these gun control bills. So as to why we in the United States are importing a group of people from third world countries with no connection or no interest in connecting up with the American founding, the American experiment, the ideals of the revolution, the American Revolution, the ideals of the Constitution and the text of the Constitution, they come into the United States and, the reality is a lot of them want to undercut what made our country great. And that's why I keep saying that the number one issue, in my opinion, and no one supports the Second Amendment more than I do, but the number one issue when it comes to protecting the Second Amendment and America values and American culture is the immigration issue. You cannot bring people in with no connection to American culture or heritage and expect them to vote for anything other than what they're used to. And that is no good if you support America as we understand it and our Constitution as we understand it. And anyone that misses the immigration issue, all these issues, because remember, if you overwhelm the country with people that are going to vote for communists and socialists like Mondami, let's say in New York City, if he becomes the president, it doesn't matter what happens because they're going to pack the Supreme Court with 20 left-wing justices. They're going to make Ketanji Brown Jackson the Chief Justice of the United States, and whatever good has happened involving firearms and the Second Amendment in the past will all be swept away. The exact same thing we're seeing in Virginia right now. Luckily, we have President Donald Trump in the White House with Harmeet Dillon and other people like her that are willing to fight for our rights, but we just as easily could have had another 4 years of Joe Biden or Kamala Harris, and they would not be riding to the rescue of Virginia. In fact, they'd be encouraging Virginia to go even further when it comes to taking away all of our rights, including our Second Amendment right to keep and bear arms.
Yeah, and that was a point, and I started making that point more, and that was a point I got from watching your channel. I hadn't really connected those dots, and I think that's one of the big value adds. The reality is the biggest threat to our Second Amendment rights in America is immigration. It clearly is, and it's a point that's not talked about enough in our movement. So thank you for connecting that. Mark Smith, the top voice of the Second Amendment, one of the most respected people on GunTube. Thank you so much for your time.
Thank you for having me on.